We'll call the Monday, July 28th City Commission meeting to order. If you would, please stand for the invocation and pledge. Dear Heavenly Father, we come to you this evening. We ask that you give us wisdom to make the best decisions for the city of Leesburg. In your precious name, amen.
Amen.
I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have no proclamations. Presentations, we have one, the Water and Wastewater Utility Impacts Fee Study Analysis and Results. Would that be you?
Yeah, why don't you guys come on,
Yep.
Sean, come on up. We, as you guys know, we've been working on presenting to you guys some recommendations and some proposals for increasing our water and sewer impact fees. So with that, I'm going to turn it over to Sean. Sean, if you introduce your company and all that and
Sure.
give us your presentation. Sean's got a presentation for us on all their findings.
Okay. For the record, my name is Sean Ocasio. I'm a senior manager with Raftelis Financial Consultants. We're based out in Maitland branch. In terms of the role on the project, I've been overseeing the project as a whole and working with the city coordinating on this analysis to look at updating the water and wastewater impact fees. We are functioning in this role as a sub-consultant to your engineers, Jones Edmonds, on this engagement. And so we've been, participating in that respect. I do want to just take a quick moment, and thank your utility staff and the whole team here. They've been very good about getting us, the information we need. It's been a very supportive process and getting everything put together. So it's been nice. We kicked this thing off in February and we're already at this stage. And I work with a lot of clients where some of this takes a lot longer to get accomplished. So it's been a nice experience here. So without further ado, what I'd like to do is spend a little bit of time this evening talking about the study and specifically, give a little bit of background and primer information on impact fee basics, some of the legal considerations around impact fees, then go into a discussion on the method that we're using and the major assumptions embedded in that to get us to the results, and then discuss summary findings and the recommendations themselves, along with some items to consider with respect to implementation. So just to start things out in terms of that primer topic I mentioned, what are impact fees? So these are fees that are paid by new growth and new development, and they're paid by this in order to essentially recover the cost of facility investments that the city has made, in this case in the water and sewer utility system. And it's meant to recover infrastructure costs, major treatment-related assets, transmission-related assets. So it's essentially the new growth is buying into the system that the city has built in advance of their arrival. These fees, they can be used to pay for growth-related projects, growth-related assets. They can't be used to pay for any operating costs or anything like that. These are meant to be paying their share of growth-related facilities and investment on a forward-looking basis. You can also use them to pay an expansion-related component of your debt payments if the utility system has debt. So you do have a little bit of flexibility with how you use these things, but they're mainly geared towards expansion-related projects and improvements to the system. One thing I did also want to mention related to that prior slide, these are paid only by new growth and new development, so these are not related to the rate side. So this isn't any sort of monthly utility bill item that your current customers are paying. This is paid by new growth or any growth that's coming in that's creating an impact to the system in terms of demand for capacity and for service. Some of the benefits to having impact fees, first having them in place, but also having them at the right level, is that it helps mitigate some of the burden on your ratepayers. So, to the extent that you have these fees in place and you have them appropriately sized based on your cost structure and everything, this helps reduce some of the burden on the rates themselves because you're getting the growth-related share of capital costs and projects funded by that growth. If you don't have them in place, or at least you don't have them at an appropriate level that's justifiable, then that burden gets pushed onto the ratepayer and the monthly customers, if you will. So it's important to have these, especially with all the growth that you guys are experiencing, and have them at the right level. That's it's coined as saying growth pays for itself or growth pays its own way. So that's the benefit there. Is it's again providing a benefit to the ratepayers here. Some additional legal considerations. So impact fee law is governed by Section 163, the Florida statutes. Came into be associated with the original case law and everything. I'll won't belabor that. But what I did want to draw out here was it's been amended numerous times since the law was created back in 2006, with some of the more recent and impactful changes being done in 2021, 2024, and even this year as well, which we'll get into in a moment. And there are some changes that are also upcoming on the horizon that'll take effect at the start of next year, January of 2026. So it's a set of statutes that go through a constant evolution over time. So it's important to make sure that we keep pace with that as things go forward. Some of the major considerations here. One of the things the Florida statutes require is that these impact fees are based on the most recent and localized data to the community, so that it's based on your information. And when they say recent, they define that as within the past 4 years worth of information. So as a part of our study, we have your most recent data up through last year and your current capital planning data from this year going forward for the next 5-6 years. So we've definitely fulfilled that requirement as a part of this analysis here. Some other provisions that are built in is from the initiation of a study to where then the fees are adopted. You have a 12-month window in which to complete the study. We're well within that horizon as well there. Some other items here, I won't go through every single bullet point. There are some important ones. When you adopt an impact fee, you have to wait 90 days before you can actually collect it, and that's called essentially a grace period there, allowing for the development community to kind of adjust its inventory pricing and that sort of thing to account for any new or increased fees on a forward-looking basis. One of the things with timing with respect to these fees, you can't charge them ahead of the issuance of a building permit, so it has to be right at that time. So there are some rules as when you can collect these, and there's some other administrative items where you account for them in a separate fund. Those are things that you already do because you already have these fees in place, so it's really a non-issue, but just mentioning for completeness there. But some of the changes that took place, and from what I mentioned a moment ago, back in 2021, the legislature passed some rule changes that relate to implementation of impact fees. And in this case, what they did was they put a couple of limits on it and a couple of phasing requirements. And what they said was, if you're projecting an increase of up to 25%, then that increase has to be phased in evenly over a 2-year period of time. If it's an increase that's greater than 25% and up to 50%, then you have to phase that in evenly over a 4-year period of time. And then the statute goes on to say, anything above 50%, you're capped or you're maxed out at that 50% increase level under normal circumstances. So those are some of the items there. But what they also built in 2021 was a provision that they call the extraordinary circumstances. And essentially what the design intent there is if a community has a special situation or an extraordinary situation, it's a set of procedural requirements that allow you to bypass those phasing rules that I mentioned a moment ago, and also even that maximum threshold, that 50%. You can exceed that if you go about that process. Now, what's interesting is, and I'll joke here, in their infinite wisdom, they didn't define what constitutes extraordinary. Now, that's it's also a good thing because they leave it up to the community to make those determination of findings and what is extraordinary for them. Some other terms that they built in some of the recent changes, you can't do an impact fee increase more than once every 4 years. So that's important to note. And then also one of the things they're changing with extraordinary circumstances in the new bill that I mentioned that'll take effect in January is you shouldn't wait more than 5 years because then there are certain restrictions you have as well. So they're kind of boxing in a little bit timings and stuff there. So in the current form, if you were to go about proceedings through extraordinary circumstances, then essentially what you have to do is you have to have a demonstrated needs study that's documenting the circumstances of your community that would make you extraordinary and justify increasing above that phasing program or above that cap. So what it'll allow you to do is if you have that justified needs study, you then have to have 2 publicly noticed workshop meetings related to discussing just those circumstances that are a part of that needs study with the community, and that's to allow input and feedback from the development community there about the circumstances. And once you go through those procedures of having the justified needs study about your circumstances, going through the 2 workshop meeting process, there's then a 2/3 vote of the governing body that's required in order to implement under that approach. And that's pretty much the conditions as they are today. What they've changed it to is what'll take effect in January is you can still pursue extraordinary circumstances and still get an increase of over 50%, but you now have to phase it. Before you could just do it all at once, you'll have to phase it over 2 or a 4-year period of time. The other thing they changed is they made it a little harder to pass was instead of a 2/3 vote, you have to be unanimous. So that's another condition to be aware of. That'll take effect then. And then the 5-year item I mentioned, that if you wait more than 5 years between impact fee updates, you just can't claim extraordinary circumstances on that next go-around. So bit dry material there in terms of some of the legal considerations, but some of the criteria in terms of designing impact fees here. There's essentially a main thing that we look for. It's called a dual rational nexus test. And essentially what that boils down to is the costs that we are including in the design of the fee itself have to be growth related. And then when we design that fee for growth, the revenues that are collected from growth have to then be applied to growth related projects. So it's trying to tie the design of the fee and the growth related cost to the usage of those revenues that are collected to growth related projects. So you're trying to relate that there. When you're designing impact fees, you have to have a reasonable level of service for the community. You can't use impact fees to fund any deficiencies in the system, so you can't use them for operations, like I mentioned before. You can't use them to fund any service deficiencies. It's only for expansion-related items. So with that kind of bit dry primer there on some of the legality items, in terms of the method overall, what we're trying to do is we're trying to design a fee that's a cost per unit of capacity of your system, if you will. And so in order to do that, what we have to do is first figure out the cost side of the equation and then the units of capacity. So that cost side relates to some of those early bullet points that you see there. We're looking at your fixed assets for your utility system. So that's every asset that's on the book for the utility system, treatment plant, the transmission lines, distribution facilities, all those sorts of things, minor equipment, everything. And then we have to allocate that by system between water and wastewater, and then from there we're classifying it by major function. So the reason we have to do that is there are certain assets that you have to leave out and certain assets that you can include. So we go through that pairing process to kind of fine-tune what that bucket of cost is going to be for the calculation, and then from there we take it to what your capacity of your system is to get a cost per unit. So everything we're going to be talking about will be on that cost per unit basis going forward. So in terms of major assumptions here on fixed asset side, the system right now has about $170 million in total assets associated with the water and wastewater system. That's roughly allocated about $67 million on the water side, about $103 million on the wastewater side. And what you'll see there, that bifurcation, if you will, assets included in the fee versus assets excluded from the fee. So we're including about 75% of the system assets, and about 25% are excluded for the reasons I mentioned that the statute requires. And the smaller type items there. So in terms of then the capital cost side on a forward-looking, because essentially the fixed assets are just looking at your existing investment to date, then we're taking those costs and adding to that your planned future costs going forward over the next few years. And so in the plan here, we have, you'll see about $127 million of total projects, of which it's broken out about $56 million of water projects and about $71 million of wastewater projects, with some of the big ticket items being noted here. Reuse mains, about $34 million, fire protection improvements, about $6.2 million. And this is over the multi-year period, the total project dollars associated with these items. On the wastewater side, the big ticket item there, the Turnpike Plant Expansion Phase 2, $39.2 million. Southern Corridor, $13 million for the Force Main Bypass, and so on. So we're looking at your existing investment, that $170 million originally, pare it down to what we can include. We look at the projects here, which is about $127 million, and then from there go, what can we include from these projects? And we get that total cost bucket to then divide by for units. In terms of the capacity of your system, on the water side, you have 6 water plants, of which about 3 of them have capacity to serve new growth right now in terms of excess capacity above current demand levels. And so what we've done in the analysis is we're isolating for the cost of those facilities that have capacity to serve growth and then relating them back to their units, if you will. So total system treatment capacity is about 28.8 MGD. When we look at those facilities that you have that have ability to serve new growth that's coming, that's about 3 plants there. That's about 20 MGD, million gallons per day. When we adjust that down and we look at your current flows that you're flowing at the facilities, you have about 60% of your facility currently remaining. However, what's important to note there is you're experiencing a lot of growth right now, and so you're going to be eating through that as developments with the different PUDs and the villages and whatnot come on board. So you have projects in the plan to try to account for that. Like on the wastewater side, your current facility is about 8 million gallons a day of treatment capacity, and with that Turnpike improvement project, it'll go to 9.5 million gallons per day. Current available capacity is about 42.32%, but again, that's going to be used as you continue to grow. So you're building new facilities in order to accommodate that growth, which is essentially the purpose of the impact fee, to fund those expansions that growth is causing you to make. So in terms of the fees themselves, what you'll see here, existing fees today on the water side, $1,175. On the wastewater side, and this is per equivalent residential unit, $2,778 per unit, for a total of $3,953. With the analysis we did using the updated assets, using the capital plan and all those items, what we're getting on the water side is an increase to $2,039 per equivalent residential unit, and on the wastewater side, $4,567 per unit, for a total of $6,606. Just to give a sense of scale there, that's an increase on the water side of about 74% and about 64% on the wastewater side. So some significant increases there, for a total overall average increase of about 67%. The far column to the right is just showing if you were to implement using the statute approach where you're capped, you would be capped at that 1762 level there on the water side and that 4167 on the wastewater side, for a total fee of 5929. So if you were to use the phase-in approach over 4 years and cap out at the 50%, that would be the fees you would have in place by the end of the 4-year window. Whereas what we're calculating would be the maximum fee that you can justify. In terms of overall comparability, how those your existing fees and proposed fees compare to a number of communities that we looked at, and what you'll see here is right now you're on the far right side, lower end of the pack, and then at the fully calculated level, the fully proposed level, it puts you just a little over the average fee level from the surveyed communities here. One thing I did want to mention here is, why do you see such a disparity across all these different communities? There's a myriad of reasons as to why you'll see different fees in different places. It can be an issue of, what sort of treatment facilities does each, municipality have? What are the age of those facilities, in terms of how they're doing things? Are they, adequately funding their renewal and replacement needs, or have they been pushing things back for a while and it kind of artificially lowers the cost? Were they lucky enough to get sufficient grant funding to maybe defray some of these costs as well? So there's lots of different things here. Source of water supply can be another one, and so it's when I show the comparison here, it's just that it's just a comparison of the cost per unit of capacity. But there's a lot of things embedded in it that the comparison doesn't really show. One thing I did want to mention with some of these municipalities shown here. We work with a couple of these, and we know that some of them are going through this process right now. City of Castleberry is doing it. City of Apopka is doing it. City of Sanford is doing it. Claremont has approached us about wanting to do an update as well. So even though your relative position here would be increasing, assuming the fully calculated level, what I would just note is odds are other communities are doing these types of studies as well. So the relative position, increase might be mitigated there a bit, because the same capital cost increases that you all are experiencing, all of our clients, we're seeing throughout the state are experiencing. I work with the one over there on City of Sanford, and not to air out their laundry, it's public information. Their multi-year capital plan back in 2019, so the 5-year period of capital improvements that they wanted to do was about $195 million. I work with them each year as a part of their planning process. That same capital plan is closer to $300 million now, just because of capital cost inflation that they're experiencing. And municipalities everywhere are experiencing this. It's not just unique to even the utility systems. I see this with fire departments where, 5 years ago, a pumper might have been $500,000, and now it's closer to $1 million. So we're seeing asset acquisition costs, we're seeing construction costs all across the board increase, very significantly and at an extraordinary manner over the past 5-6 years. So with that on the comparison side, in terms of implementation, so the water impact fee on a per ERU basis, based on the fully calculated level, is increasing about 74%. The wastewater increasing about 64%. So those fully calculated amounts are higher than the 50% that we talked about earlier in terms of the standard statutory implementation approach of phasing in over time. So the city has essentially two main options here. You can either choose to implement through the standard statutory approach, which would be phasing in over a 4-year period to that 50% cap and being capped out there. One of the cons to that is because the fees are going to be perpetually under recovering compared to what they should be based on the fee analysis, the differential there, if you will, on what would have been recovered from growth is going to instead have to be recovered through the rates, or those projects would have to be pushed back or something like that. So it does create a potential for a burden on your existing ratepayers by pushing that in that manner. The alternative is you can try to implement through the extraordinary circumstance provisions that we talked about, which were those procedural requirements from before. And presently, that's the staff recommended option based on our analysis. Just kind of talking about some of the circumstances that would go into that justified needs analysis. You've experienced a significant population growth recently, and it's continued to project on the horizon. You've grown from 27,000 persons roughly to about 37,000 just between the span of time between about 2020 and presently. So that's an average about 6.5% per year on an average annual basis. Just to give a sense of scale, the average for the state is less than 2% per year. So that's very high growth, and it's actually one of the highest ones I've been working with you guys is that level of growth there. It relates to units that are approved for development right now. Since 2020, there's about almost 40,000 units that have been approved for development, of which about 14,000 are related to the villages entitlement units. So this level of just significant growth that you've been experiencing, that you're planning to continue experiencing, is what's creating the need for the expansion-related projects in your capital plan to provide service to those new units. So it's directly linking the cost that you're planning to incur to that growth, because that's what's driving it. Then the other thing I mentioned a moment ago was the cost to construct these new facilities has been increasing significantly for the past 5-6 years. Just as a rough sense of scale, the Consumer Price Index has increased about 27% since 2019, and that's just like your average bucket of goods type of costs. When we look at Construction Materials Index, that's gone up about 40% since 2019, and that's just materials. That's not on the labor or the cost or anything associated with demand that bids the price up and so on. So we're seeing very significant increases there that are extraordinary compared to normal circumstance. Just as another little bit of scale here, when I look at your existing investment in your wastewater facilities today, and essentially divide that out per the gallons of capacity that facility can treat, it comes to an average cost per gallon investment of about $8.64 per gallon. When we look at the construction cost of the new facilities, that expansion to the Turnpike facility, the increase there, on a cost per unit basis, it's about $26.13 per gallon of capacity. So it costs 3 times more to build now than what you had in service from before. So it's a very significant increase, and I've seen it even higher in other communities. I did a study with the city of Mount Dora, and their new facilities plans for wastewater expansion was $43 a gallon of capacity compared to their embedded investment, which I believe was about $13 or $14 existing. So it's a phenomenon that we're seeing across the board, and it differs materially from what's been seen historically in terms of these costs and in their increases. So one step further on things to consider with respect to implementation. So I had mentioned on the front end that there was some changes that were upcoming in the Impact Fee Act that were going to take place in January. Those relate to what was called SB 1080. And one of the items to note here was, I mentioned it a little bit earlier, was if the fees haven't been updated in more than 5 years, then you can't implement through that extraordinary circumstance approach that I was just describing a moment ago. Now, the good thing at least is that doesn't take effect until January, so there's still time to implement with that methodology. But I at least wanted to note that there is a horizon by which it'll then, that approach will change. The other one that is recently passed legislation was SB 180. Now, this one here has to do essentially with the impacts of a hurricane. And I'll just read the text. For 1 year after a hurricane makes landfall, an impacted local government may not propose or adopt restrictive or burdensome procedure concerning review, approval, or issuance of a site plan, a development permit, or development order. So the question that is raised just from this newly passed bill is, does this affect the implementation of impact fees? Because they're not specifically called out in the listing of items that they're restricting, but you could conceive of a good faith argument that could be made that says, well, the payment of an impact fee is a part of the process to get your building permit and those things. So does the raising of an impact fee fall under, what these restrictions are speaking to? If yes, then there's potential that this bill could impact how you go about implementing the impact fees going forward and the increases that we're talking about. If not, then it's a non-issue, but it's something we at least want to bring up because it's so new. Just to be honest, we don't know the answer right now.
Yeah, and if I could just jump in, Sean,
Yes,
I
sir.
appreciate you pointing this out, and I don't want to interrupt you too much, but just to really kind of hammer home what he's saying is this was just passed, and we really don't know what that language means exactly. It's pretty broad and pretty vague and expansive, so it's certainly a possibility. It seems that a number of cities are still planning to move forward with the process at this point, even despite SB 180 having been passed. Sort of looking at the idea, I guess, that SB 1080 sort of specific to impact fee procedures and how you go about raising those. And so I think a lot of people are sort of the mindset, sort of typically with construction of statutes, is if you look at a specific statute, that's typically going to be what's governing the scenario, or a broader, more general statute is not going to govern the situation. So the long and short is I think it's very important to point out SB 180 and that it's a potential concern, but we don't know exactly what the impact of that is on things like raising impact fees at this point, and whether a court would consider that part of this development permit process or not.
So, may I ask, please, Sean, what will happen in January 2026? I mean, what should we do? What will we do?
Well, that's the trigger. That's a different bill. So and it's a little bit confusing because you see they've got the numbers just about the same for each bill. 180 is specifically dealing with emergency procedures and hurricanes and things like that. That's the one that talks about the burdens on the development process. SB 1080 is the one that changes the extraordinary circumstances analysis. And so as Sean was saying, that January 2026 mark, the importance there is that's when the new impact fee regulations go into place and when the extraordinary circumstances option would change from what it currently is right now.
So I guess the extraordinary circumstances is the question. What is extraordinary?
That would be a lot more difficult to do
Yeah.
once it hits January 2026, particularly with the 5-year limitation and other restrictions. So it's going to be much easier to do the extraordinary circumstances for purposes of raising impact fees beyond that 50% threshold if you do it before January 26.
Thank you.
With regard to the 1 year of impact, are we talking about Milton specifically then?
Yes.
So that's an October 9.
That's
So
right.
we would
And
have to do this between October 9 and January 1.
right, and just to kind of add to that as well, the emergency management bill is I guess the way it reads is, though it's limited in scope, it actually covers the entire state. So every municipality is covered by the emergency management bill that was by SB 180.
So with that consideration in mind, what we put together with the city manager was 2 alternative implementation schedules for the recommendations. The first of which would be if the consensus is to move forward on the extraordinary circumstance approach in order to get the full fee levels implemented fully, as opposed to over time, then the extraordinary circumstance workshops could potentially take place under scenario 1. the August 11th and August 25th meetings. Subsequently, you could then have your ordinance reads, your first and second ordinance reads associated with the passing of the ordinance on September 8th and 22nd to have an October 1 effective date. And then you could start to collect new fees, starting in January 2026 because of that 90-day wait you have to do between when you adopt it and when you can actually collect it. As an alternative, if we look here, then you have workshop potentials for September 22nd, October 13th, ordinance readings October 27th and November 10th, with the fees being effective December 1st. So you would be able to collect the fee starting in March, but in either case, you would still be ahead of that January 2026 deadline in terms of the implementation. And I believe, and correct me if I'm wrong, but I believe, Mr. City Manager, the intent of Alternative 2 was if we're worried about SB 180 and the timeline there on the declaration, I think that was the one that was intended to be the 1 year after that point in time. So you'd be sidestepping that, but still within the time frame to get it done by January.
Yes. Now, let's grant you have a preference for 1 or 2.
No, I mean, I think probably in a perfect world, I would think that alternative 1 is perhaps the better, clearer legal path, but I think either one of them's okay.
So then with that, in terms of next steps as to how to move things forward, I think one thing that we'd want probably some consensus on would be the implementation method. Do you want to go with the standard approach, or do you want to go with the extraordinary circumstances approach and implement fast with that? There's also, some research to be done still on the potential impacts of SB 180. Then have your publicly noticed meetings for the workshops and the ordinance reads as a part of that process. Go about adopting the proposed fees at the fully calculated level, and then comply with the Impact Fee Act requirements as needed, the 90-day grace period, and update within after 4 years.
Is it possible that we can get an updated version of your presentation here? Because I think you have additional pages, or
Yes.
not quite the same.
We modified it before
Okay.
the.
Oh, okay.
So we need some direction.
Yeah, I mean, that's kind of pretty much where we're at. So, we talked to Grant a little bit this morning, kind of leaning on option alternate 1 or 2, and then kind of wanted some feedback from you all, and then we move forward with trying to implement the extraordinary circumstances.
I had a question, and I know that this is just wastewater and water, but do we need to address police and fire impact fees as well? And would we do that at the same time?
No, I think you need to do that at a separate time period. I don't think you want to hold up your wastewater. Probably, it's something we need to talk about. If there's interest in looking at, so there's the update for police and fire. So the city's local impact fees, off the top of my head, water, sewer, police, fire, rec, I believe library. Those are the 6 impact fees we have. If we were going to add a road one, I don't know. I would defer to Sean on that, on how we do that. There's probably increasing impact fees versus implementation of new ones, probably a little different process.
That's been our understanding. If it's a first-time implementation, then there's no increase to be calculated. It's just brand new thing.
So we'll get back to you on that.
Okay.
That being the look at where our other impact fees are and do they need an increase and the creation of new. So that's a separate assignment. I think we need to keep pushing forward on
Gotcha.
water and
Okay.
sewer. So we'll have to come back to you on that.
Thank you.
Just a question for Grant. You did recommend, you said option 1. Could you expand on that? Just
Yeah, I think it's cleaner. I like the idea that you have the ordinance implemented, you have the 90-day grace period, everything runs before January 26 hits, and the law changes. I think that, again, I think either one is okay, but if we could have everything done before the law changes, I think that's a better process than the other way.
So do you need a motion?
It sounds like it's moved with option 1.
Just,
I think a motion would be preferred.
okay, so I'd like to pursue, as we said, option 1 on the expansion.
So we have a motion on the floor. Do I have a second?
Second.
So we have a motion and a second on the option one. Any discussion on that? Yes. Can we go back to that page, Sean? Sure. There it is, though. And then do we have any public comments on that? Seeing none, I will take a roll call. This is on the implementation of the impact fees? You have public comments on that? Okay, yes. This is on the impact fees only. Roll call?
Commissioner Connell,
Yes.
Commissioner Berry,
Yes.
Wait, you good? Okay, sorry. I
Was
thought-
it Berry or Berry?
Commissioner Berry,
Yes, I'm sorry.
Mayor Reisman.
Yes. Thank you. I was a yes.
Yes, sir.
Okay.
Oh, yeah.
All right. Any questions, last minute questions for Sean? Or- Thank you very much, Sean.
Thank you.
We will move to the public comment section. This section is reserved for members of the public to bring up matters of concern or opportunities for praise. Please note that issues raised during this time will not be discussed in detail during the current meeting. They will either be referred to the appropriate staff or scheduled for consideration at a future city commission meeting. Each speaker is allocated 3 minutes to provide their comments. Kindly adhere to this time frame to ensure equal opportunity for all participants and to support the efficient conduct of the meeting. Thank you. I would ask that if you are here, I would kindly ask regarding the shuffleboard courts that you hold those comments till August 25th, as that's when the vote will happen. If you do have public comments, please state your address and name for the record, and we will begin public comments. Yes, sir.
Steve Clark, 109 South Lake Drive, Leesburg, Florida, 34788. I am exercising my right to public comment regarding the Palmetto Street Shuffleboard property dispute. The Leesburg Shuffleboard Club, or LSC, and Forward Paths, two valuable Leesburg nonprofits, are unnecessarily pitted against each other over the Palmetto Street Shuffleboard courts. Demolishing the courts to benefit the Forward Paths would dissolve the LSC, an inequitable outcome that the city of Leesburg can avoid by accommodating both organizations. The LSC has used and maintained the courts for decades, has remained respectful despite Forward Path's false allegations that the LSC inflated membership numbers and/or opposed their mission to support homeless youth. They insinuated a not in my backyard mentality, but no evidence of any such treatment has been observed by anyone. This conflict stems from Commissioner Jimmy Burry's proposals favoring Forward Paths, where his wife and son hold leadership roles. Conflict of interest. Commissioner Burry's actions raise a clear conflict of interest under Florida's Code of Ethics, Chapter 112, Florida Statutes, and the Sunshine Amendment, Article 2, Section 8. Public officers may not use their position to secure a disproportionate benefit for family or affiliates, even without a financial gain. By prioritizing Forward Paths, Burry disadvantages the LSC, a similarly situated nonprofit, violating fairness principles described in both the above statutes. For legal context, the LSC's 54-year use, and 40-year maintenance of the courts may establish legal claims, including prescriptive easement or equitable estoppel, supporting their right to continue using the property. Former Mayor Bill Polk also noted the potential for discrimination lawsuits if the city favors Forward Paths over the LSC. Impact on similarly situated parties. Both nonprofits serve vital community roles. Forward Paths for homeless youth and LSC for seniors. Demolishing the courts grants Forward Paths a disproportionate benefit while dismantling LSC, undermining equitable treatment required by Florida ethics laws. Call to action. The city must resolve this conflict transparently. Investigate Commissioner Burry's actions and find a solution that preserves both organizations.
Thank you, Mr. Clark.
I would like to leave a copy
You
of
can
my
sit it right
statement.
there on the corner of the desk, sir. Yes, sir. Are there any other public comments? Yes, please state your name. If you have a public comment, please form a line. Just make the efficient time. Please state your name and address for the record.
Hi, my name is Carolyn Colucci. I live at 4952 Sawgrass Lake Circle. It's in the Plantations, Leesburg, 34748. I was in here a month ago with concern over the Manor Oak development wanting to access our property, which our community attorney has addressed by a letter stating that we are private property, and hopefully it gets resolved through the organization here, so we're not burdened by having strangers come onto our property per se. But I'd also like to reference something from February 13th, 2023, from the Daily Commercial regarding our significant growth and development. There's a postage-sized map hanging in City Manager Al Minner's office with proposed housing developments marked in big pink chunks. If the shapes were weighted, they would tear off the south end of the map. That map shows doubling the size of the city of Leesburg population within a few years. Now, there's a statement in the same article, we didn't go out and seek growth. Minner said last January when the City Commission unanimously approved the 2,300 city single-family and 740 multifamily unit Whispering Hills development. Growth comes to us. It's to the city's job to manage growth and, if annexed, to provide services. We're not going to stop growing. That's become very obvious to many, many residents in this town. The amount of growth that's happening is exponential to our services, our community. What should be a 10-minute ride from the plantation to here at 10 o'clock this morning, according to MapQuest, would take 23 minutes. At 5 o'clock at night, it's going to take closer to 45 minutes, barring any accidents. The communities are being burdened to a ridiculous amount by this growth. We need to put control down and look at our utilities, look at our facilities, and look at our roads. Our roads can't handle it. And when I hear that the Villages is all golf cart, I gotta say garbage. Every golf cart driver potentially has a car or two in their home, and our roads can't handle it. Thank you.
Thank you. Yes, ma'am.
Good evening. Thank you for allowing me to speak. Name Caitlin Brody, 146 Bullfrog Lane, Umatilla. Well, I'm not a resident of Leesburg. I'm here tonight because one of your commission members, District 3, has made decisions that directly impact me, my property, and my neighborhood. This individual is also the building official for Umatilla. Holding both positions is a violation of Florida law. Article 2, Section 5A of the Florida Constitution clearly prohibits anyone from holding two public offices simultaneously unless specifically authorized by law. Additionally, Florida Statute 468.619 recognizes that building officials, because of the powers and duties they exercise, are considered public officers. That means serving as both a city commissioner and a building official at the same time is not permitted. It has been confirmed that there is no interlocal agreement between Leesburg and Umatilla that would make this dual role lawful. But this issue goes beyond a legal technicality. As Umatilla's building official, he allowed unpermitted work, allowed deviations from signed and sealed engineering plans, issued certificates of occupancy that do not reflect actual conditions, and failed to verify required legal documents. Even worse, he's communicated about residents, including myself, with developers through personal emails and phone calls. Florida law requires building officials to act without favoritism and avoid conflict of interest. This is not happening. This is about accountability. It's It's about trust. Our communities deserve fair and equal enforcement of the law, not special treatment for developers with connections, which I see that your city residents here do not like development. What's more concerning is that the same developers and builders who are allowed to cut corners in Umatilla are also building here in Leesburg. This raises serious questions about whether similar issues may have already been happening or could happen in your own city. I'm asking you tonight to take a serious look into this situation, take corrective action, because when one person holds too much power and uses it carelessly, it's not just unethical, it's dangerous. Both cities and the people who live in them suffer the consequences. We cannot allow conflict of interest and abuse of power to be swept under the rug. I'm not here to speak up for myself, but for every resident who deserves transparency, fairness, and integrity in their local government. It's time to bring accountability. It's time for darkness to come to light, because what's happening is not right and it's not fair. And to you, Mr. Connell, I will continue undercovering everything. I will not stop until there's accountability and the full truth comes to light. Thank you.
Thank you. I would ask one second that our city attorney address the allegations against our commissioners, but I want to say that our staff does a phenomenal job. We have one of the best building officials in the state, and when you come up here and say that about our staff, you're undermining their talent, their ability, and their work ethic here in the city of Leesburg. You said that there's false things going on in our city.
In Umatilla.
You said in this city. So you're,
Yeah, I didn't
Yours-
catch you either. I thought you were saying our building official is the Umatilla building official as well.
You're C3.
well, you said those same builders are building homes here, which is alluding that our building official or our staff is doing a wrong job, a poor job. No, time's up.
I would like to address that real quick. I am familiar with her. Just to clear the record, when I first ran for office back in 2019, this issue was addressed with the city attorney Morrison. I'm not an elected official of Umatilla. I'm a hired employee. I'm a part-time employee at that. As far as her situation, I didn't inspect her home. I didn't do her plan review. It was all done by third party. I'm just a building official of the city. When they elect to use third party, all the building official does, his role or her role in that is you process paperwork. I had nothing to do with the construction of her home, nor have I had anything to do with the builder who built her home. I don't know if I've ever done an inspection for the builder who did her home. What goes on here in Leesburg on the builders, I have no control over the daily permitting or inspections of what goes on in this city. I mean, so her claims are, they're outrageous to come to a public meeting and say. I mean, they're probably borderline slanderous, but it's absolutely outrageous for her to come here and make these statements. But just to clear the air, had nothing to do with her home or anything.
Yeah, and I appreciate that, Commissioner Cannell, in addressing that specific situation. I think obviously I have great respect for Fred and his role and the discussion that you had with him about that issue before. Then moving on to Commissioner Burry's situation, again, this is something that we had addressed at the last meeting. We've looked into this. I've talked to Commissioner Burry, and since the last meeting, I've spoken to him again about additional issues and found that there is no conflict at this point. Again, we have looked at all the statutes and constitutional provisions that are in play. I've questioned him multiple times, and I've got no factual information to support that there's a conflict of interest. I, of course, appreciate information from the community. If anybody has any information, you're welcome to submit that to me, and I'm happy to review it. But again, to try and clear the air on that point, really the issue here is a little bit different in large part because of the volunteerism as opposed to sort of a paid employee type scenario. And I see what you're saying, but I've read many ethics opinions on the issue. And again, I've talked to Commissioner Burry about all of these issues and factual allegations that have been floating around. And I don't have any concerns about a conflict based on my discussions with him. As I said, anybody that has any information, you're welcome to submit that to me. I'll give my email address right now. It's Grant, Grant, at Stone, STONE, and AND, Gerken, GERKEN.com. And anybody can email me there, any information. I'll be happy to look at that. I'll be happy to talk to you. But, like I said, I've talked to Commissioner Burry multiple times about it. I'm not concerned based on the information I have. And would just like to move on at this point. And again, appreciate everybody's concern and comments on the point.
Thank you, City Attorney. Seeing no other public comments, we'll close public comments. We'll move to the consent agenda. Routine items are placed on the consent agenda to expedite the meeting. If the commission or staff wish to discuss any item, the procedure is as follows. 1, pull the items from the consent agenda. 2, vote on remaining items with 1 roll call vote. 3, discuss each item pulled and vote by roll call. Are there any items the commission would like to pull this evening? No items? If I can get a motion to approve the consent agenda. We have a motion and a second. Any further discussion? Any public comments? Seeing none, roll call.
Commissioner Burry?
Yes.
Commissioner Berry?
Yes.
Commissioner Connell?
Yes.
Mayor Reesman?
Yes. Item 6, public hearings and non-routine items. During public hearings and non-routine items, the commission requests that those in attendance respect the process and maintain order. In accordance with Robert's Rules of Order, please refrain from speaking out, cheering, or applauding during these proceedings. Your cooperation helps ensure a fair and respectable hearing. City Attorney, do we need to swear in anyone for tonight?
No, sir, Mr. Mayor, we are clear on quasi-judicial hearings
Yes,
this
sir.
evening.
We have no second readings. We have 1 first reading. Would someone please introduce 6B1?
I'll introduce and ask to be read by title only, please.
An ordinance of the City of Leesburg, Florida, amending Section 13, Motor Vehicles and Traffic of the Code of Ordinances by amending Section 13-5 to adopt the maximum rates for towing and storage of vehicles as set forth in Florida Administrative Code Rule 15B-9.010, providing for conflict, severability, codification, and an effective date.
Thank you, Ms. Andy. This is a first reading. Any discussion from the commission? Any public comments? Seeing none, this will lay over till August 11th. Would someone please introduce 6C1?
I'll introduce and ask to be read by title only, please.
Resolution of the City Commission of the City of Leesburg, Florida, authorizing the mayor and city clerk to execute a lease agreement extension with Blue Heron CPA for space at the Leesburg Incubator and providing an effective date.
Move for approval.
Oh, second.
We have a move for approval in a second. Discussion, city manager?
Yeah, this was, this item, the Blue Heron lease, it was brought up at the last meeting. Commission asked me to place this on the agenda for this meeting. The short of the matter is that this lease is an existing lease at the incubator next door. The lease expires September or last part of August. And the Blue Heron has asked for an extension. The staff report says we favorably recommend the lease that was put on. That's an error. The staff does not recommend a lease as requested, which I'll explain here shortly. In negotiating a renewal with the lease, we really couldn't come to a staff terms. So the lease that is on the agenda for you is the terms that are requested by Blue Heron, not by staff. Blue Heron petitioned you all last month, and their request was sent to them subsequently, but long story short, their request is the lease on your agenda tonight. So it's a 1-year lease for $250 a month. Staff is in opposition to this proposal, basically for 2 reasons. A, I'm not sure at this stage that Blue Heron meets the intent of the incubator being a place where businesses start, germinate, and are not in existence. Blue Heron has offices in the region as well as this office, and they're clearly a quality firm that may not need the incubator support. And then secondly, the extension is actually a decrease in their current rent amount. I think their current rent amount is $400 a month. That's in the packet if I misstate it. For those reasons, we would recommend either A, let the current lease expire and not renew it, or at a very minimum, extend it for the current amount. I believe the owner of the business is here. He can present to you, if you want to hear from them, their side of the request. Briefly, I'll give it to you. At the meeting last month, the petitioner requested that because they help local businesses have found fraud and because their expertise in accounting, they feel like that is a benefit for startup businesses. So therefore, they should be eligible to be in the incubator. So really, the matter is for you to decide on how you would like to extend, sunset, or move forward with a different version that's before you.
Any questions from the committee?
Yeah, so if a new business comes to you, what is a new business's introductory rate?
It looks like the existing business. It typically, we run a 3-year lease. The first 24 months being around $300, $350 a month, and then it bumps up for the last 12 months, which would be the last 30, the last year, the 36 to the neighborhood of $450. Those numbers again are in your packet.
Okay.
But I can affirm this at $250. That's definitely
That's lower.
That's below what the current tenant it pays and below what we think we could probably bring into the incubator.
And do we have other potential tenants that would be interested in the space?
I don't have potential tenants ready to move in there now. In the past 12 months, we have had different petitioners seeking interest. So I don't think the space would be hard to fill at the typical standard of the 36-month that I just described.
And the total time Blue Heron has been there has been 1 year?
No, they'll
been
be
there
there 3
3
years
years.
at the
Okay,
end
so
of
I
their
see.
term, which is the end of August.
Nathan?
Just want to answer some of the questions as well. So Nathan Gauger, 1318 Quail Court. This is our only physical office. We do not have multiple offices throughout the state. We traditionally do go into incubators to help small businesses grow and provide that expertise. The initial phase is the largest phase for issues and mistakes, and oftentimes it bankrupts the business. We have one office. It is the smallest office in that entire building. It is in the back corner. There are currently 13 offices, I believe, in that building. 6 of them are occupied by the Leesburg Chamber of Commerce. I believe 4 of them are occupied by the Lake Economic Area Development. One of those offices is a storage closet for liquor. In the back kitchen, you currently have warehousing for restaurant goods. My approach in what I sent in an email is that I hope that I can help small businesses expand and do better in this city and not face those same financial non-compliance issues that the vast majority of them currently do, whether they see it or they don't see it. It usually leads to issues 5-10 years down the road. If you've noticed your Main Street down here, you have consistent churn in the businesses. We've helped many of those stay alive. In this case, we have 3 of them that would have been non-compliant had they not been with us because they had received prior advice that are currently still on your street because we fixed their situation before they had $10,000 to $15,000 worth of fines. I'm not trying to use that as a constant business. If there is the case that someone wants to move in, as what you've added to the lease in this iteration is a 30-day out, you guys have the ability to kick me out and I will not complain one bit if you guys want to exercise a 30-day out. Currently, there are 2 offices that are unutilized. If you choose to have the liquor storage, if you choose to have some of those other offices still fulfilled by these other tenants that are not paying either, that's fine. I'm wanting to pay for what I believe is a fair market value rent. If you look at the square footage, the price per square foot, it is beyond what the vast majority of other businesses are paying as a price per square foot for co-working space around here. And I feel like I'm being 100% fair. This is the smallest office in the entire building and not really asking for much here.
So please explain again, you are not willing to pay the additional because of the square footage of the
Currently,
office that you have? Is that that's your complaint?
I don't believe that it's fair to pay $70 a square foot whenever all of the other real estate around the city is maxed out around $40 to $45 a square foot if you're looking at co-working space. I feel like $70 a square foot is,
What's your current rate? What's your current monthly rate right now?
my current monthly rate is 400.
400.
And our original 350 right now. It was 300 and then 350. So we were subsidized by the USDA rule grant through the original contract, from what I understand. I don't know if we've ever received that. I don't know how that really works because I haven't seen any funds being distributed since 2019. So I don't know whether that grant still exists. This is also, if you read the email that I sent to everybody, this is also the move that every other incubator in the entire nation is making, where they're involving professionals so that business success happens. If you don't have me in there, I only request that you actually utilize that as an incubator space and put small businesses in that space. Because right now we have 2 small businesses that have been there. We had Deb Jane Consulting, and we had a mental health facility, and I believe that mental health facility left because of financial issues. And I don't know if you know anything about that specifically, City Manager, but you may have the story. My understanding, it was financial fraud that caused that for-profit business to remove itself from that building.
So just my opinion, I would be in favor of your current rate. I can't go and approve a decrease. I have a lease at the airport. I pay CPI increases every year, and if you get a decrease, I'll be right back here going, I want a decrease in my rent.
Okay.
So I respect that, but I would approve the current rate for a year with a 30-day notice, but I can't approve anything outside of that, for me personally.
I would not argue with the current rate. I would just argue with a $100 rate increase where my intention is not to utilize that 40 hours a week. It's not really a great space to build a business. I welcome you guys to walk through it. It's just a great space if people actually want to build a business here to hopefully get more information. Much like you need an attorney for you guys being here, you just had a consultant come in from Maitland. You don't have those professionals here providing that service to your local audience. That's what I'm trying to provide here.
Thank you. Any other further commission comments?
You're okay with the lease that's proposed?
The lease as proposed, if you were to increase it to our current rate, I am more than fine with that, and I do not mind a 30-day out. I would request that you do add that we are renting only a suite rather than the entire building, because currently as written, it looks like I'm renting the entire building, and there are other occupants in 13 rooms, so I would just prefer a singular suite.
Yeah, I mean, that modification can be made. I think the concern probably is likely to deal with the liability associated with suites that are not being rented by this particular business. So I understand the perspective. That's a pretty easy change to make on the document. So if everybody was in favor of something and had attached a condition to make that modification subject to review by me, I'm happy to make that change with the city manager and the tenant to clarify, again, that he's only renting one suite with certain access rights to common space, I guess, that would be associated with the building.
So just so I understand, your purpose in the incubator is to help other businesses in the incubator, or are you doing private work
So
out of that?
in this case, both. I would love it if I could help other businesses that are in the incubator. There are no other businesses in the incubator, and have been no other businesses other than one business, which we did help for the 3 years that we've been an occupant.
Okay. So you're currently not helping anyone in
I
there
have no opportunity.
because there's no one there that needs your service, or they
Accurate.
don't?
11 of the 13 offices are fulfilled by nonprofits.
Okay. So in essence, you're using it to help run your business. You're being paid by other entities for your services.
Correct.
So I could agree with the current contract. I could go along with that, but certainly not a reduction in what someone new to the incubator is going to pay. I don't think that's fair.
So you're saying the 350 rate?
The current rate, yes.
And you're asking for 250, correct?
I would not be opposed to 350. I am well opposed to $450, $500. That's where my opposition comes in, is I looked at traditional square footage. I would also, if you guys wanted to put a mandate that I have free hours available to those businesses that seek business in this area through those nonprofits, that I make my time available and give 2 hours or do a quarterly seminar on what's happening in tax or what's happening in the world as far as business. I feel like that's much needed. Currently, your residents travel to Eustis or travel down to Claremont for that information, and we could make that available here if we wanted to really push that. But that would also require participation from those economic development entities that are already inside the incubator that technically are there to manage the growth of this county.
Current lease proposed is the 350.
No, the lease that's in your packet that your motion is on is a one-year lease at 250.
50.
Yeah. 250, you're correct. So does someone,
So I'd like to make a motion that we raise that level to the current rate of $350 a month, that remains in effect for a year, and that you have a 30-day out. Those conditions would,
And he wants a specific suite number added, which we can do
Yes.
administratively.
we'll get
so we would specify his suite as the leaseholder. Is that,
Yes, sir.
Yes.
okay?
All right, so we have a motion for Commissioner Burry. Do we have a second?
I'll second, yes.
All right, any further discussion?
That 350 is fine with you.
That is fine with me.
Any public comments? Seeing none, roll call.
Commissioner Berry?
Yes.
Commissioner Connell?
Yes.
Commissioner Berry?
Yes.
Mayor Reesman?
Yes. And one final thing in regards to the incubator, I would just ask that the city maybe put an advertisement plan together or work with someone to advertise that facility so it can get back to its full potential. Thank you.
Was that an amended motion? Because you had a motion on the floor and you just had one vote, so I'm going to assume that was a motion to amend and then you need to vote on it again? Did you catch that?
I think we did have the amended motion, right?
So that was a vote on the amended motion.
So now we need to.
So
vote
now you
on
need to
that.
vote on the motion.
Okay, so we need to vote on 6B or 6C1
Thank you.
with the amended motion in place.
I move that we
Approve the lease as
approve the
amended.
lease as amended. Yes.
Yes.
Thank you.
We have a motion
Second.
and a second. Any further discussion? Public comments? Seeing none, roll call.
Commissioner Connell?
Yes.
Commissioner Berry?
You have a public comments in regards to that? Well, let us finish the vote and then we're in a vote process right now.
Commissioner Berry?
Yes.
Commissioner Berry?
Yes.
Mayor Reesman?
Yes. And this is in regards to the incubator? Please state your name and address for the record. You have 3 minutes, sir.
My name is Anthony Washington, 1011 East Boulevard. Just listening to what was going on today, I don't think it's one of those major issues when you see a resident and a gentleman who wants to provide a service. I don't think we should major in minor things. If you look around, you talk about square footage, that's in every real estate, every city. That's what they base usually the dollar amount on. So I want to support you as a resident, and I don't think you're asking for, excuse me, I have a chest cold, but I don't think you're asking for much. And I think for a person to come up and want to provide a service to the community, you should be commended on it.
Thank you. Moving along to informational reports. Any questions on the informational reports? Seeing none. City attorney items.
No items this evening. Thank you, Mr. Mayor.
Thank you, sir. City manager items.
Yeah, I have two items for you this evening. First, I just kind of have a heads up item, let you know what I'm going to be doing. And this goes, I don't think I'm speaking out of turn, but nor accepting or denying any liability or the incident that took place. But about a month ago, a couple of weeks anyway, a young lady was hit by a foul ball at a Lightning game. She received some damage to her face. Since that time, we have put up some signage, and Travis started looking at some costs for netting down third base side specifically. We're going to move forward to procure those numbers and bring you a price to add the netting. I think those numbers are going to be significant when they come to you, but nothing will be done as far as installing that netting without coming to you all. But I think the proper way to trigger this is to go ahead and commence a procurement process to get the numbers and bring them to you. I'm just going to tell you this. I think probably netting down the third field line, believe it or not, is going to be in the six-figure range. I don't want to say a number because I don't want to prejudice any bids of what we're anticipating, but I do think it will be an expensive endeavor. But nonetheless, we're going to move forward with that, and then you guys can give that direction when that bid's on your desk. The second issue I wanted to bring up, it's just kind of a reminder. The mayor has spoke to me about it a number of times. I think about a year ago, maybe a year and a half ago, the commission passed a resolution that authorized the construction of a baby box. I don't think that baby box specifically, for the purpose of a baby box is for a mother or family who doesn't want an infant to put the baby in a safe box where the baby can reach public personnel safely. We had that long discussion, again, about a year ago. The state legislature this year passed a resolution or a law that said that these boxes were now legal. In that regard, one of the things that stopped us from putting the box in a year ago was concern that the box didn't have the proper product approvals and wouldn't be able to get a building permit. At this stage, those fears are subsided to a degree. I do think that there's two issues that give me some pause in signing the agreement that the resolution did give me the agreement to do. And that is A, I don't want to prematurely sign off on a contract to leave the city liable for the purchase of a product if we can't install it. And then those two installations would become problematic if the building official still was concerned about product approvals. But then B, we also need engineering and design because the baby box is going into a wall of a facility. So that will concern removing a portion of the wall, adding a header, and those type of things. So design and engineering will be needed on that. I've been working with Amanda McLee on this item, with the the breakfast rotary, I believe, Sunrise, and they are willing to pay for the box. So the box is about $25,000. They're going to write a letter that says that they support that. In the interim, I have Deputy City Manager Hicks working on trying to get some price estimates and figuring out what we need to do to procure construction services to cut the hole in the building. I have no idea what that will cost, but again, I will bring that matter back to you as a contractual item. If it falls below the threshold of my authority, I'll probably bring that back to you anyway, just as an informational item. So we'll be working on that as well. So we'll be working on a procurement for netting at Pat Thomas, and also we'll be starting to procurement on a contractor that would cut a hole in the wall. And the scheduled place is Fire Station 61.
Oh, that's what I was going to ask you. Okay.
Which is here on Canal.
I was going to ask you what was the building. Also, as far as a person that was injured, how is it a young kid or adult, or do you know how serious?
Young female, I don't know the age. I saw the pictures. I'm going to guess she was in her 20s, early 20s.
Was there is there anything there now as far as netting down to third base? Is nothing there?
There never has been.
Gotcha.
Yeah. Now, they did, I'm not sure if they filed a claim yet. I know we've got some information, and the information was forwarded to our risk manager, Lisa Earl. So she's managing that case. So
Okay.
I'll provide more details as they become available.
Thank you, City Manager. Is that it?
That's it.
Thank you. Roll call.
Commissioner Berry?
Nothing tonight.
Commissioner Berry?
I just wanted to say congratulations to myself.
I was getting there.
I had a ball. I represented the city of Leesburg with Stepping Out for Education, and I walked away with being the top female dancer for Saturday night. A great experience and a wonderful, wonderful cause for helping our children in Lake County schools and the teachers. Thank you.
I was getting there.
You can go where.
Commissioner Connell?
Yes, just one thing. There was and I have spoke to the city manager and the city attorney about this last week, but there was a publication that went out that I thought it was the cart in front of the horse, and I was going to quote a portion of it. This publication shall serve as notice of the City Commission, the City of Leesburg, Florida's intent to dispose of real property 309 South Palmetto Street. Like I said, it says it shall serve as notice of the City Commission. That's our intent. We have not had a vote on this. And I think this should have been discussed, and we should have voted on. That was our intent, to dispose of this property before a notice went out. Again, I think from time to time, this commission does get the cart in front of the horse on things. I believe we should have had major conversation. It wasn't our intent to do away with almost 2 acres of wrecked property before the notice was posted. That was our intent. I don't know how the city manager felt like that was our intent to do so, since we hadn't voted on. He's never asked me if that was my intent one way or the other. I don't know if he spoke to any of the other commissioners about it, but I just don't think this notice should have went out prior to us having a lengthy discussion on it and a vote.
Can I just tag on to one quick thing on the back end of Commissioner Cannell's comment there? Just to point out, and Al might have more information, that there was a notice that was published regarding this property that's inviting proposals from the community. So if anybody out there does have any proposals for this property, redevelopment of the property, there is a 30-day window open now to submit that information to the city, submit that proposal to the city, so that that can be considered by the commission in the context of considering whether or not to dispose of the property. And as Commissioner Cannell mentioned, it does indicate an intention to dispose of the property. The city is not required to dispose of the property, having run that notice. So it's a notice to invite proposals, again, from anybody interested that might have a proposal for redevelopment of the property. So anybody out there that has a proposal, please submit that. And again, just to clarify, this does not guarantee that the city will get rid of the property. It's just a procedural requirement that needs to be met because it's within a CRA's boundaries. And so again, the idea is to invite proposals and have everything before the city so they can make a decision on what the best proposal is for the property.
Yeah, and just as some other background based on the commissioner's comments pointed at the city manager, I will say the following. This is a standard operating procedure in disposing or considering the disposal of surplus properties. This process was not done in prior years before Stone and Gherkin became our city attorney. And so my commentary is not throwing anybody under the bus, but rather discussing SOP in a public forum, which I have no issue with. When we operated with Macklin Burnstead under the direction of Fred Morrison, we never did advertisements seeking ways to have clear title prior to disposing or selling property. At that time, I can't speak for the then city attorney, but that was the process. Stone and Gherkin was, and under Grant's leadership, was the directive that part of the statute to make sure we had clear title on disposing of lights, that we needed to advertise. and specifically on community property that was located within a community redevelopment district. So as we endeavored to move off into this concept that we've contemplated now with the shuffleboard courts, with forward pass, with what to do with this specific 2-acre tract, it was agendized as directed by the commission for August 25th. And in so doing, I received a call from Grant, who said, we might need to advertise this. I told this to Commissioner Cannell when he asked me about this. I believe it was late last week, and I did not talk to any other commissioners about it, believing it was SOP, so the advertisement used the standard language. The only quibble I would add in there about cart before the horse is as Grant has kind of educated me on the process, is that when you consider donating or selling or disposing, or it is the intent, as Grant now explained the definition of intent publicly, that you want to have all the information available to you when you take action to dispose of property. So that is another proposal. So I'm sure it's a catch-22 there. If we endeavored off to have a vote without the ad, then you might have a proposal that would come forth that would offer to purchase the property or give you another option better than what you think is available for you. So the purpose of the ad is to flush out all the options. In the next 30 days, we might have somebody, we might not. We might have somebody who says, hey, we'll give you $500,000 for that property. That $500,000 now might look better than keeping the shuffleboard courts or donating the property to Forward Paths. The purpose of the article and the advertisement was simply to inform the public that this is under consideration, so that when you do deliberate on the 25th, you have all the information and you make the best determination according to what the collective wisdom of the council is on the 25th.
I have a question, and I just want to go back, I don't know how many years. The tennis courts that were behind Big Lots years ago, what was the decision, and did you have to go through all of this when it was decided to remove those tennis courts?
The tennis courts
Where
next
the
to the racquetball
racquetball,
courts that were in Susan Street?
Yes.
We did not sell or dispose or advertise of the demolition of those, other than the considerations of all the things that we talked about to bring forth the concept of the Susan Street project. So in the Susan Street concept, we contemplated rectangle sports at that facility, and we talked about demolition of other facilities that would be there.
Okay, that's what sure. Thank you.
But there was but in reference to an advertising of disposable property, we never advertised that that would be demolished.
Thank you. I just wanted to be clear. I wasn't aware. I just knew they were there and then they weren't there. So, and for other other reasons to bring in more sports activity in that area.
Yeah, and I think that scenario of was there an advertisement when we demolished the tennis courts at Susan Street is a different concept than the legal requirement of disposal of land. So you're talking about a singular facility
versus
this question is the disposal of property.
Gotcha.
That's right. Disposal of
Thank you.
property is the trigger under the CRA statute that's caught this.
Right.
this
And
particular
moving
lot.
and also one of the things about cart before the horse, when you have donated a couple of parcels here recently to the CDC, those advertisements went out ahead of when the commission donated those 2 parcels. I can't remember which ones they were to this. Now, granted, they weren't 1.7 acres, but that process of an advertisement of intent to donate parcels that were owned by the Community Redevelopment Agency or located within the Community Redevelopment Agency went out before the commission actually did the warranty deed to the CDC. So this is the exact same process. So on the 25th, you may or may not choose to donate the property. And if you don't, that you've covered your bases. So all you have done is set yourself up in a position to either A, keep the property and move forward as is, or B, donate it if you so choose, with the notation that community that's located within the greater Leesburg CRA has been advertised.
And just real quick, I'm gonna make a statement, that's it, is I understand the legalities of why it had to be advertised. My point is, I think it should have been discussed and voted on of the commission that that was our intent to dispose of the property before the advertising went out. I don't know that is our intent to dispose of it. I understand we'll decide the 25th, but I just think that decision before the advertising went out should have been discussed and voted on, that that actually was the intent of the commission to dispose of this property. That was my point. Thank you.
Thank you.
Mayor Reisman?
Thank you. Just giving everyone a heads up, on August 8th at the Lake Square Mall, I think it starts at 7, but if is the Chamber's Back to School Teacher Appreciation, where we'll have like 10 different schools there and all their teachers, and it's pure chaos, but it's fun. Serving them breakfast and gifts, and so I really appreciate that, what the Chamber does. Lastly, I just want to say thank you to all of our staff, department heads. We are the city we are because of you. We appreciate you. It's a little disheartening when people come in here and discredit you or challenge you and say you don't know what you're talking about, but you have years of experience. We rely on you, so I want to say thank you for all your hard work and everything that you do day in and day out to keep our city running. With that, I'll take a motion to adjourn. We have a
Motion to adjourn.
meeting adjourned.